Anybody else from the Free State? So far, we are the two.
But maybe to
Honourable
assist you,
Chair.
is there anyone from the Free State who is present? Okay.
Yes, I am.
Can you give us your name, please?
Khadebe, like Honorable Senator said.
Yes. Okay, you were introduced. Thank you. But I understand there are other members from the Free State who are supposed to join us. Perhaps when they join us, they will introduce themselves. From KwaZulu-Natal, Honorable Mtembu.
Thanks, Chair. I'm present with two members, Advocate Masondo and Nonton Ndlovu. Thank you.
Thank you. From the Northwest, we have Honorable Motswana. Are you present? Honorable Motswana? Okay. All right, we'll verify as the meeting continues if anyone from the Northwest has joined us, but we did get confirmation. From the Western Cape, we have Honorable Allen. Honorable Allen.
Thank you, Chair. From the Western Cape Provincial Parliament, we have Member Peter Marais, Member Brinkhuis, but we have also submitted apologies via our procedural officer for Member Botha, Member Kama, and Member Bosman. And as I indicated, private chat to you via this platform, that Member Philander will join us in the next 17 minutes. We are glad to be here. Thank you so much.
Thank you, Honorable Allen. Your signal is not too great. You're breaking when you speak. I'm not sure if you're able to try and fix that in the interim.
I will do so, Chairperson. Thank you so much.
Thank you. Honourable members, we received apologies from Gauteng and Mpumalanga. Those provinces are currently having sittings, so they are unable to join us. In terms of Limpopo and the Northern Cape, we did not receive any confirmations, no apologies, but I'd like to just see if they are present. Is there anyone here from Limpopo? Okay, Northern Cape. Okay. No, thank you, honorable members, and welcome welcome everybody to this meeting, the Deputy Minister, members from all provinces, hearty welcome to you. As I indicated, that we'll be dealing with the recognition of Customary Marriages Amendment Bill, which is a Section 76 bill, and it aims to address a constitutional court ruling in that Section 7, subsection 1 of the bill was inconsistent, of the Act was inconsistent with the Constitution, and it was declared invalid. And this is because the section limited the right to human dignity and discriminated unfairly on the basis of gender, race, ethnic or social origin against women who entered into polygamous customary marriages before the 1998 Recognition of Customary Marriages Act, suspended the declaration of constitutional invalidity for 24 months to afford Parliament an opportunity to remedy the constitutional defect. The court handed down judgment on the 30th of November 2017. This means that Parliament was required to pass remedial legislation by the 29th of November 2019, and we're well beyond that time. However, as a committee, we also sought a legal opinion on this bill, and even though the time period has expired, the bill does contain a read-in provision, which is currently in place to address the key issues contained in the bill, and these read-in provisions will therefore remain in force until the committee finalizes the bill. But honorable members, let me hand over to the department who would probably provide more information on this as they continue with their briefing on the bill. Deputy Minister, if I can hand over to you.
Very much. We did try and get a extension from the Constitutional Court on this bill. It basically got delayed because of both elections, and then it spent some time with the National House of Leaders. We approached the Constitutional Court. They declined to give an extension on the basis, as you mentioned, that there was a reading into to the provisions of the Act, and therefore nothing much, according to them, hinged on granting the extension or not. But obviously the idea would be to get the bill finalized. I think Ms. Ross, will, or if not her, she'll say if anybody else is with her, will do the presentation. But the bill is simply addressing the Constitutional Court case, which is the Ramohovi and others matter. Just to say that there are other amendments needed to the Customary Marriages Act, and in fact, when it went to the National House, this is now by the department, not by Parliament. Parliament also had descended there, the National Assembly. They came with a whole lot of other amendments that they wanted to the Customary Marriages Act. So we accept we do need to do further amendments to the Customary Marriages Act, but for the purposes of this bill, it's to address the deficiency pointed out by the Constitutional Court. But if I can hand over to Ms. Ross.
Please do, Deputy Minister. Ms. Ross?
Thank you, Chair, and thank you, Minister. Just okay. Let me just put the presentation up. Oh my God. Thank you, Chair. Oh, bad network quality. Chair, like you and the Minister have already indicated, the main objective of this.
Ms. Ross, my apologies for interrupting. We are unable to see the presentation. Are you struggling to put it up?
Sure, it's up on my side. I've shared it. Let me try again.
Chair, I can see the presentation. I'm not in the same. I don't know if, whether other members can see it or not. But
okay, let me verify. Members, are you able to see the presentation?
Yes, Chair. Yes, we can see.
Yes, ma'am.
Okay, I think it's probably myself. So continue, please.
And on my side, also,
thank you,
but it's fine.
Honorable Zanamela, you would have a copy of the presentation. So please continue then, Ms. Ross. Honorable members, we'll try and follow. Thank you.
Thank you, Chair.
Ms. Ross?
Chair, can you hear me?
Yes, I can.
Chair, am I audible?
You're very audible.
Oh, okay. Like you and the Minister have indicated, the purpose of this bill is to effect amendments to the Recognition Act 1998. The amendments emanated from the Constitutional Court decision in the case of Ramohobi and others. The bill, in a nutshell, aims to amend the Act, that is the Recognition of Customary Marriages Act, in order to further regulate the proprietary consequences of a customary marriage, which would be a property, private property consequences or rights of a customary marriage is entered into before the commencement of the Recognition of Customary Marriages Act came into being, which was in 1998. And the aim thereof is in order to bring the provisions of the Act, the Recognition of Customary Marriages Act, in line with the Constitutional Court decision in Ra Mohobi. The crux there in that case, or the court held, declared Section 7, subsection 1 of the Customary Marriages Recognition of Customary Marriages Act unconstitutional, with unconstitutional in the sense that it unfairly discriminates women on the basis of gender, that is, women who are in polygamous marriages, on the basis of gender, race, ethnic, or social origin.
Ms. Ross?
Two or rather three already. Currently, Section 7, subsection 1 of the Act provides that the proprietary consequences of a customary marriage entered into before the Recognition of Customary Marriages Act came into operation continue to be governed or regulated in terms of customary law. What this means is that wives who are in polygamous customary marriages have got no rights in the ownership of or control of marital property, and that the rights of ownership and control of the marital property is the sole preserve of the husband to that marriage or marriages. This was found particularly to be the case under the Bavenda customary law, because even the Ra Mohobi case emanated from the Limpopo High Court. The High Court had found the provisions of Section 7, subsection 1, to be discriminatory on the grounds that I've already mentioned, particularly or because of gender, and it ordered that a husband and his wife in polygamous customary marriages entered into before coming into operation of the Recognition of Customary Marriages Act have the right to share the family property equally, as well as the rights to the management and control of such family property. The Constitutional Court also ruled that this right should be extended to the right of management and control of the house property between the husband and the wives in each of the house property, or in the house property of each and every polygamous customary marriage that would be that men would be in. Now, coming to the actual provisions of the bill, clause 1 of the bill just aims to amend the definition of a traditional leader in order to align it with the definition of a traditional leader in the traditional leadership and governance framework. But this would be understandable because the Recognition of Customary Marriages Act is a 1998 Act, whereas the Traditional Leadership and Governance Framework Act is a 2003 Act. So it became necessary to this technical amendment so that the definition of traditional leader in the Recognition of Customary Marriages Act and the Traditional Leadership and Governance Framework Act are aligned. Now, coming to clause 2 of the bill, which deals particularly with that Ramohobi decision. Clause 2 amends that section 7, subsection 1, in order to provide that the proprietary consequences of a polygamous customary marriage.
Ms. Ross, sorry to interrupt. Somebody, I can hear somebody calling me. Can you hold on, Ms. Ross?
Matiwane.
Yes, Matiwane.
Chairperson, I'm not sure who's controlling the presentation. I'm not sure whether it's only myself. The presentation is stuck on slide 1. Difficult to follow through the presentation because it has not been flowing. It's been stuck on slide 1. I'm not sure if I'm the only person, that's okay. If I'm not the only person, then somebody must correct it. Thank you.
Well done. Is any other member experiencing the same problem? Honourable members?
Yes, it was, Chair.
It was.
Yeah.
Perhaps,
but it must move with her to make things easy for us.
It's possible that her signal is not too good. Gershwin, are you able to upload the presentation?
Yes, Chairperson, I can.
Okay, yeah, will you just deal with the logistics as quick as you can? Honourable members, I don't have anything on my screen, so I'm unable to see. Oh, yes, I can see the presentation now. Ms. Ross, if you could indicate where you were, or maybe just go one slide back from where you were.
Chair, I was on slide 7, which deals with clause 2 of the bill.
Okay. Okay. I think honourable members can see the presentation now, so can I. Please continue, Ms. Ross.
Okay. Clause 2 of the bill, Chair, aims to amend section 7, subsection 1 of the Recognition of Customary Marriages Act in order to provide that the proprietary consequences, which I've indicated that they refer to the private property rights of a polygamous customary marriage entered into before the commencement of the Act, which is the Recognition of Customary Marriages Act, are that the spouses in each of the marriages have a ownership of management and control over the marital property. The bill, in correcting that, it provides that the rights in the property must be exercised in respect of all house property by the husband and the wife of the house consent jointly and in the best interest of the family unit constituted by the house consent. And the rights in respect of all family property must be exercised by the husband and all the wives. You know, not only the husband as it is in the customary law and, you know, particularly the vendor customary law, like I've indicated, must be exercised jointly by the husband and all the wives and in the best interest of the family. The bill further provides that each of the spouses or each spouse in the customary, in the polygamous marriage retains the exclusive rights over his or her personal property. And the bill provides that the term marital property, house property, family property, and personal property have the meaning as to them in terms of customary law. The effect of this amendment, Chair, is that the proprietary consequences of a polygamous customary marriage under or in terms of the bill will no longer be governed in terms of customary law, whether it was entered into before to effect of the Recognition of Customary Marriages Act. Chair, can I just mention that in respect of these categories of property, that is the house property, family property, marital property, and personal property. In the portfolio committee stage, the concern was raised that the bill does not define this term and terms, and that it is necessary that the terms are defined. However, after the deliberations and because the Department of Home Affairs is already dealing with the reform of marital law, and all these issues are being looked into. And also, even when we as a department consulted with the traditional leaders on what could, on what the actual meaning of these terms were, there was no consensus. So it was then decided that it would be very difficult to reach consensus without the benefit of extensive consultation. And because this bill aims to give effect to the decision of the Constitutional Court, which you've already indicated that should have been remedied already by 30th November 2019, it was then decided that those issues, the definitions of these types or categories of property are not placed in a back burner, but would rather be ventilated in during that reform process and the research process underway in the Department of Home Affairs. Chair, clause 2 further amends section 7, subsection 2, that is in clause 9 now, in slide 9. Subsection 2 of the recognition of the Recognition of Customary Marriages Act, and this amendment is in line with, in order to give effect to the decision of the Constitutional Court again in the case of Gumede, in which section 7, subsection 2 of the Act was declared constitutionally invalid because the section only made customary marriages entered into after the commencement of the Recognition of Customary Marriages Act to be marriages in community of property. Thus, it excluded persons married or in customary polygamous marriage before the recognition of customary marriages. So the aim of this clause, the amendment in clause 2 in respect of the Gumede judgment, is to correct that position, and which would then mean that all customary marriages, whether entered into before or after the commencement of the Recognition of Customary Marriages Act, will be marriages in community of property and of profit and loss, except where the spouses themselves have decided that they are going to exclude community of property by way of an international contract. Then clause 3 of the bill, which is accounted for in slide 11, contains transitional provisions, and it provides that the bill will not invalidate the winding up of the deceased estate that, or a deceased estate that was finalized or after the transfer of marital property that had already taken place before the commencement of the Recognition of Customary Marriages Act. A further transitional provision is to the effect that the bill will not apply to the transfer of marital property, where at the time of the transfer, the person to whom the marital property was to be transferred was aware that the marital property in question is subject to a legal challenge. The minister has already spoken about an application to court because this the remedial legislative amendment should have been put in place by 30th November 2019, and the deputy minister said an application was made to court for the extension of the deadline, which extension was rejected by the Constitutional Court. And the interim order of the Constitutional Court has since become final. However, the legislative amendments that still need to be made urgently in order that there is legal certainty and in compliance of the order of the court, and for the legislature to fulfill its role of making legislation. Thank you, Chair.
Thank you, Ms. Ross. Deputy Minister, do you have anything else to add?
Summarize it this way, and that is that when the Recognition of Customary Marriages Act was passed, it set up a new system relating to the sharing of property. But it said that marriages entered into before that act was passed would remain according to customary law. I presume that Parliament did that. This was a bill from the first administration. I assume that Parliament did that thinking that the parties to a customary marriage had rights and they couldn't interfere with those rights after the fact. I assume that was the reason. What this bill does is says that all customary marriages, that applies to all customary marriages, those entered after, which was the case before, but the change it made was even those entered before need to be in terms of community of property or sharing of property. That's basically the gist of what the bill is about. It's not a complicated bill.
Thank you, Deputy Minister, and thank you, Ms. Ross. I think the Deputy Minister quite summarized it quite nicely. Let me first request from honourable members of the Select Committee if there's any follow-up question and or comment that you'd like to make. If you can please give me an indication. If you have any comment or follow-up question. Honourable members.
Oh, I'm okay so far.
Thank you, Honourable Mfayela. My apologies because the system I'm using, I'm unable to see if members have raised. I see Honourable Moimang has raised a hand. Okay, I take it's Honourable Moimang who wants to raise a question. Honourable Moimang. over to you.
Thank you, Chair. Chair, let me start by appreciating the presentation as led by the DM. My clarity-seeking question relates to the coverage of this bill. Does it also extend to other marriages that are governed, that could either be governed by Islamic law, or what is the situation with regard to those marriages that are governed by Islamic law? Because I know that at some point also there was an issue. There was a judgment, just that I forgot the judgment that also made a pronouncement on that. Thank you, Chair.
Thank you, Honorable Moimang. Any other member? Okay, I see there's no other member. Maybe then just from my side, Deputy Minister, the Ramuhovi matter the Constitutional Court judgment around that was some time ago. And in essence, there has been a lacuna in terms of the legislation. And I think it's for the past 10 years or so. Maybe if you could just indicate why has it taken like this long to address this gap? I think in terms of the amendments to Section 7, subsection 1D, related to marital property, house property, family property, personal property, in that they would have meanings ascribed to them in terms of customary law. And Ms. Ross has also indicated that there's no common and/or agreement in customary law around these terms. I mean, is the expectation then that the courts would have to bear the burden of such statutory interpretations? And just finally, okay, while I also understand that the Department of Home Affairs is embarking on this other process of establishing a legislation, marital legislation, and possibly there will be a process in that where these kind of terms would probably get some attention and there'll be some clarity around it. Yeah, I think those are the questions from my side. Deputy Minister, if you could respond to that, then I'll ask provinces if they have any other comment and or questions for clarity. Deputy Minister, over to you.
Thanks. I think Ms. Ross can answer some of the detail, but maybe just to say that the Marriages Act falls under Home Affairs. That's the Ordinary Marriages Act. Civil Unions Act as well under Home Affairs. And they've also taken responsibility for religious marriages, Islamic marriages. The case that is being referred to hasn't yet been confirmed by the Constitutional Court. So that's where that one is. But it's Home Affairs that are that are working on having a single marriage act that applies to everybody, no matter what kind of marriage you have. So just let me give that by way of background. Ms. Ross, if you could just explain about I think it was the Gumede judgment. Ramuhovi was from 2017, so that's quite recent. The 2-year deadline was November last year. It's Gumede that was a while ago, and I think if Ms. Ross can explain on that, and then also the issues of property and anything else she wants to add.
Ms. Ross.
Thank you, Chair.
Chair, there was a question on whether the bill only addresses customary marriages. Yes, because the amendments are in respect of an act that regulates customary marriages. And one would also see that from the requirements of a valid customary marriage in terms of that act. And then it will become clear that it is in respect of marriages in terms of customary law, which would mean the customs and usages traditionally observed among the indigenous African peoples of South Africa, which form part of the culture of those people. And there are requirements that talk to the issues of the lobola, and which requirements will not necessarily be the requirements in other marriages. So it is specifically in respect of the customary marriages. On the issue of the Gumede judgment, why it took this long to implement, to effect the legislative correction. I must say it was an oversight which we came across when we were working on the amendment in respect of Section 7, subsection 1, the Ramohodi judgment. But I admit that it was an oversight on our side for which we profusely apologize for. Yeah, I think those are the issues I wanted to speak to, Chair. Okay, there was a question. I'm sorry, Chair. There was a question on whether the definitions of your house property, family property, and marital property will continue to be or will be interpreted by the courts. Yes, Chair. Until such time that the legislative certainty is in place, because there we need the benefit of extensive and comprehensive consultation. Like I've mentioned, because the thing is, like, if you look into the Ramohodi matter, it was particularly in respect of the customary law as practiced by the Bavenda. It doesn't mean that it is not the customary law regarding the regulation of proprietary consequences of a marriage in other cultures. You may find that it is there, it's just that in the Ramohodi judgment, it made its way to court. So, however, it was when we were consulting and tried to get certainty from the other cultural groups in the Republic and from the traditional leaders and other groups that we consulted with on this matter. There was not even near to agreement as to what these terms mean in the respective cultures. In one culture, it was understood to mean the one thing, which was different to what it is understood to mean in another culture. So there, the benefit of extensive research and consultation is needed in order to reach the consensus and, a certainty, if at all possible. And unfortunately, that would have to be subjected to the interpretation of the court until such time that we have legislative certainty. However, the the process that is unfolding in Home Affairs is looking at the whole array of these issues, which would then, we believe, would be able to put to rest the areas of, or limit the areas of disagreement in these matters, in respect of the definition of these matters. Thanks, Chair.
Thank you, Deputy Minister. Anything else to add, or are you okay?
I'm okay, Chair.
Okay, thank you. Thank you for those responses. I'm going to now request members from provinces if they have any question and or comment to make. I'm going to go province by province, given that I do have some system issues. From the Eastern Cape, Honorable Matiwani and your team, is there any question for clarity or comment that you would like to make?
Honorable Chair, thank you very much. From our side, I don't think we don't have any comment. Any question, but a comment to say that because we did not bring the entire committee in this meeting, perhaps our request would be that there will be a time that will have to be arranged by ourselves with the select committee to come and brief us before we engage in an exhaustive public hearings. But again, the challenge that is going to come, which I think all of us we have to think about, is how we intend to consult our communities better. Because being a rural province, we'll have to find better mechanisms on how we're going to consult our communities, given the fact that they may not have access to all the mediums of information dissemination that are there in an urban space. The last point, as you can imagine, some of the rights contemplated on the amendment would require that we consult even transitional arrangements would also have to be consulted with our communities, because the rights contemplated, they talk about property, and I can tell you it's not going to be an easy thing. We will have to consult our communities as it were. Otherwise, we welcome the work done. It's good progress, and we hope that Chair, through you, we will have time that will agree on the date wherein the team will come down and brief us further before we engage our communities. Thank you very much.
Thank you, Honorable Matiwani. I'll go to the Free State, Honorable H. Smith.
Honorable Chair, I must comment and say that this amendment is very proactive. In what I see here, I think it protects women better as in the past. I'm not so fully on data when it comes to these laws. I'm also new and learning by the day. But what I've read here and what I've gone through and Googled a bit, I think I will take it to my committee and we will make inputs if it's necessary. We are a collective group of people, but thank you for the opportunity.
Thank you, Honorable Smith. I'll go to KwaZulu-Natal, Honorable Mtembu. Do you have any comment or question that you'd like to ask?
No, thanks very much, Chairperson. On behalf of KZN, want to welcome the work done, and we are going to follow the position of Eastern Cape, whereby we will require that the presentation be done to the committee, and then of course, so that properly we prepare ourselves for the engagement with the community. It is a sensitive bill, but I think the work that has been done, there's a light on the tunnel. Thank you very much.
Thank you, Honorable Mtembu. I don't know if the Northwest has joined us. Honorable Motswana, are you with us?
No, thanks. I'm with you, Honorable Chair, and thanks for the opportunity.
No, welcome.
Yes. we are going to also follow the same route that Eastern Cape will be following. The bill does raise quite complex and technical issues involving issues of properties and so on, and the complex issues into customary measures going as far as back as time immemorial. So it is important that we'll then afford the select committee to come and brief the committee on the province before the province could embark on a public hearing. So as to extensively we can go and touch base with our people and ensure that what product then we brings to Parliament should be the best product that has been an input emanating from all people concerned on the ground, because whatever that we do should be that there's deeper understanding of what the bill is all about. We appreciate the presentation and we'll do best to try to assist Parliament in arriving at the decision.
Thank you, Honourable Motswana. The Western Cape, Honourable Allen and your team, do you have any comment and a question? Honourable Allen?
So much, Chairperson. Can you hear me?
Yes, we can hear you.
Thank you so much. Following the comments that has been made from various provinces and with the state law advisors tagging the bill as a Section 76, we would obviously then want to ascertain if there is a timeline already in terms of when it will be officially referred, so that we can then get our, so that we get accordingly. We have a number of members that were unable to join due to the late notification of yesterday only. Hence, the time of us in order to prepare. Thank you.
Thank you very much. I think that covers all the provinces that are present. I don't know if anyone from Limpopo or the Northern Cape has joined us. If not, thank you very much for all of those comments. Deputy Minister, you'd note that these are more on procedural matters. And maybe just to indicate to honourable members in the various provinces that indeed we would need extensive public consultation in terms of this bill. But also in light of the COVID-19 pandemic and the fact that we would probably require public participation and or public hearings, it might be a bit difficult for yourself. So I think just in terms of procedure, what we will do as an office is have a consultation process with all provinces in terms of how we can take this bill forward and to cater in terms of how provinces can be able to do their public consultation or their public hearings. So we will engage you. In the past, you would note that there used to be a 6-week guideline. It remains a guideline. However, it's a guideline, like I'm saying, but the point is that we expect extensive consultation on the bill. So we will do that, the necessary consultations with each and every province, and then we'll send you a directive around what the common expectation is from all provinces. I think in terms of the bill being referred, the bill has already been referred to provinces, if I'm not mistaken, once the National Assembly has already adopted the bill. But the formal referral or the procedure that will flow, obviously being 9 provinces, we would want some level of consistency so that we all end up at a certain point in terms of getting the necessary inputs or comments from the public on the matter. So once again, let me thank honourable members from the various provinces for taking this time to join us in terms of this briefing. I think even though you've joined us, we will send representatives of the select committee that come from your various provinces to further give yourselves as well as the rest of your committee a briefing in terms of the bill. And I'm sure you would have further engagement on the content of the bill, even clarify yourselves further before you take it out to the public for public comments. Thank you very much for your attendance. And yeah, I think Deputy Minister, you're still with us for the second item. Honourable members from provinces, you're free to remain in this meeting if you have time, but if you wish to leave, you are also free to leave. As a committee, we're going to continue with the next agenda on our item. Thank you very much, honourable members from provinces. Honourable members of the Select Committee. Sorry, did somebody want to say something? Honorable Ellen, your mic is unmuted, so I'm not sure if you wanted to say something.
So sorry, Chairperson. No, I'm covered. Thank you.
Okay. No, thank you very much. Honourable members, we move to the second point on our agenda, which is to receive a briefing from the Department of Justice on the Prescription in Civil and Criminal Matters Amendment Bill. Honourable members, this bill aims to amend the Prescription Act of 1969 to extend the list of sexual offences in respect of which a prescription does not start to run under circumstances. The bill also amends the Criminal Procedure Act of 1977 to extend the list of sexual offences for which prosecution may be started after 20 years has lapsed since the date of the alleged commission of the sexual offence. And let me once again also invite Deputy Minister to take us through the presentation. Gershwin, Deputy Minister, let me hand over to you. Thanks.
Okay, thanks. And then I assume again, Ms. Ross will be speaking to the presentation. Just to say for the benefit of members, I know not everybody's a lawyer, but prescription is basically, there's a time period, and if you don't charge somebody within that time period, then once that time period has passed, you can't charge them. So what this bill is doing is that there's no prescription for serious sexual offences like rape, but there was prescription for more minor cases. And this bill is taking that away. And then it is also dealing with, there's also prescription in civil matters in that you have to institute the action within a particular period of time. And it's also addressing that sorry, just something appeared on my screen. I don't know if it was mine only or everybody got it, but it was a bit distracting. So that's the background to the bill. It's also in terms of a constitutional court judgment. With this one, we tried to do it quicker. So in fact, we first brought the bill to the National Assembly after the High Court had ruled on the matter. And that was actually a mistake because the Constitutional Court wanted further amendments made. And then there was also the issue of civil prescription. So we had to withdraw the bill and then reintroduce it. But it just goes to show the problems we did try with this one to get it passed. The deadline was actually 14th of June. It got delayed by COVID because the National Assembly did finalize it early in the year, but only passed it recently. But again, similar to the Customary Marriages Bill, what's been read in will take effect until this law is passed. But if I can hand over to Ms. Ross.
Apologies, DM and Chair. I'm with Mr. Heng Dupré, who would be doing the presentation, and I'm handing over to him. Oh God, where is it?
Okay, Mr. Dupré.
want to share. Wait.
Let's just go to that screen.
Which one? This one.
This one.
Open.
Don't worry about the presentation.
Sorry.
Good afternoon, Madam Chair. Henk de Pre, Department of Justice. I'll take you through the bill with your permission. It's a very short bill. By way of background information, and maybe just to repeat what our deputy has just said, is that Section 18 of the Criminal Procedure Act, as it was prior to the Levenstein case, indicated that only in respect of the most serious offences, like for example murder, rape, etc., compelled rape, the right to institute a prosecution would not be prescribed. So in other words, the other side of the coin is all the other offences, the right to institute a prosecution in respect of those offences, prescribed after a period of 20 years has lapsed since the commission of the offence. So in other words, if I want to lay a charge of theft with the police, that must be done within a period of 20 years. Otherwise, the National Prosecuting Authority does not have the right to institute the prosecution anymore. The Levenstein case, in the Levenstein case, the constitutionality of Section 18 was challenged specifically with regard to the fact that Section 18 only referred to a few sexual offences, namely rape, compelled rape, the trafficking in persons, and then also using a child for pornographic purposes. The court found that that distinction is not justifiable because in respect of all types of sexual offences, there is a psychological impact on victims that may delay them coming forth and laying charges. The Criminal Procedure Amendment Bill, as the Deputy indicated, was introduced into Parliament on 30 May 2018 as a proactive step to address the shortcomings or the perceived shortcomings at that stage of the Section 18 of the Criminal Procedure Act. However, the Constitutional Court hasn't delivered its judgment by that time. Although the department had the opportunity to brief the Portfolio Committee on the contents of the bill, the Portfolio Committee never invited public comments. Shortly thereafter, it came to the Minister's attention that the applicants in the Levenstein case, with reference to Section 18 of the Criminal Procedure Act, shifted their attention to Section 12 of the Prescription Act. Now, Section 12 or the Prescription Act deals with the prescription in civil cases, which is, of course, the contrast of prescription in criminal cases. The Minister at that stage then decided to inform the Speaker that he will withdraw the bill and then prepare a single amendment bill to deal with both the shortcomings of the Criminal Procedure Act and then also with regard to the Prescription Act. Now, if I may turn our attention then to the bill itself, Clause 1 then of the amendment bill aims to amend Section 12(4) of the Prescription Act, merely to indicate that under circumstances,
Sorry, Chairperson.
Yes.
The slide is not moving on my side. I just want to check if other members, if the presentation is moving.
Other members?
Same thing here is not.
It's not. Is it being projected? Okay. Mr. Dupré, can I just request Gershwin to project the presentation for us or to load it for us, because we seem to see it better when he does that. I suspect your signal is not that good. Okay, I'm not sure what slide you were on.
Madam Chair, with your indulgence, it's a very short presentation. Maybe we could start at the second slide, which is the background information. On that slide, you will just get yes, that is the slide. That is just the background information to indicate to the committee the history involved in the Criminal Procedure Amendment Bill that was introduced into Parliament in May 2018, and that is then the next slide, slide number 3. If we could go to that slide, please. Yes, there we just merely indicate that the Criminal Procedure Amendment Bill was introduced into Parliament before the Constitutional Court delivered its judgment, and that the Minister then eventually informed or advised the Speaker that that bill will be withdrawn because the applicants have then in the meantime directed their attention to Section 12 of the Prescription Act. Now, the next slide, Madam Chair, merely gives an indication to the committee of all the parties that were consulted during the process leading up to the introduction of the bill. And I might just add to that, that in the Portfolio Committee, CUSATU, the Commission on Gender Equality, the Helen Suzman Foundation, the Women's Legal Center, and the Embrace Dignity organization made representations to the Portfolio Committee. All of them were in favor and support of the bill. We can now turn to the next slide, which is slide number 5. The next slide, Madam Chair, now indicates to us what the bill aims to achieve, and that is, first of all, in clause number 1, to amend Section 12(4) of the Prescription Act in order to align it to the judgment that we received in the Levenstein matter. I might just add in this regard, the applicants intended to attack Section 12(4) on exactly the same grounds as they attacked Section 18 of the Criminal Procedure Act. And then merely indicate to you that in clause 2, the main aim there is to amend Section 13 of the Prescription Act, which relates to Section 12, but uses the term insane, which we prefer now replacing with a reference to a person's mental, intellectual disability, disorder, or incapacity. And then the last slide, Madam Chair, that's slide number 6. Clause 3 then deals with the proposed amendment to Section 18 of the Criminal Procedure Act, which provides that under certain circumstances, the right to institute a prosecution never prescribes. Those were prior to the Levenstein matter limited to the most serious offences like murder, rape, and compelled rape. And in view of the Levenstein judgment now, it is proposed that Section 18 should be amended to refer to any sexual offence, whether that offence was committed in terms of the common law or in terms of statutory law. In the Portfolio Committee, there was a concern raised with regard to those instances where the right to institute a prosecution may have already prescribed, and the question was raised whether this Act, by merely amending Section 18 of the Act, will then revive that Act. The debate wasn't really concluded or maybe I should rather say that the department approach was to advise the committee that it might be safer just to clarify the legal position, and that is in subclause 2 of the proposed new section 18.2. It is expressly indicated that the right to institute a prosecution in respect of any sexual offence in terms of a common law statute, which may have lapsed before the implementation of this amendment bill or commencement of this amendment bill will be revised, and that is to clarify the legal position. Madam Chair, maybe I should hand over to your committee if you would like to maybe raise some questions, but from my side, that is what I would like to bring to your attention at this stage. Thank you, Chair.
Thank you, Mr. du Preez. Deputy Minister, is there anything else you'd like to add?
No, Chair. Thanks.
Oh, cool. All right. Thanks a lot, Deputy Minister and Mr. du Preez, for that presentation. Honourable members, I'm going to once again hand over to you if you have any comment or any question for clarity. I know that we're still going to have some time for ourselves to familiarize ourselves in more depth in terms of this bill. But if there's any question or comment that you would want to make, please do so now. If I can get an indication from members.
We are posting.
Honourable. Okay, I don't know who Ndlovu is, but on members of the Select Committee on Justice, Security and Justice.
I want to ask one question.
Honourable Moimang, let me just see if there are any other members. Okay, Honourable Moimang, I don't see any indication. Honourable Moimang.
Chairperson, just want to get clarity on the principle of reciprocity, which in essence suggests that for law to apply in reciprocity, it has to meet certain requirements. Other than that, it will not apply to situations that took place before the law was passed. Maybe just to get a sense as to whether is that not a stumbling block in terms of what we are trying to do, because the principle around the thrust of the law to protect the most vulnerable group, it must be appreciated. It's a step in the right direction, in the sense that you can't raise as a defense that this matter is prescribed. I think that is the essence that I get to say, look, that can no longer be used as a defense, both in terms of civil law and also in terms of the Criminal Procedure Act. But of course, my concern is the issue of applying the law retrospectively. That is the question that I want to ask. Thank you, Chair.
Thank you, Honourable Moimang, for that question. The Deputy Minister, let me hand over to yourself and Mr. du Preez.
Look, Mr. du Preez can also have a bite at the question. It's not. It's actually retrospectivity, not reciprocity. But yes, generally laws or crimes, things can't be made a crime before the act was committed. But this is not making something a crime. It's raising the consequences of that crime, and I imagine that there would be justification anyway from the limitations clause in terms of the rights of the victims. That would be my take on it. In any event, it's the Constitutional Court that has ruled on this, told us what to do. But if Mr. du Preez can add his comments.
Mr. du Preez?
Chairperson.
Who is speaking?
Matewa, is it possible before he comes in, just one small issue?
Oh, sure. I didn't know you were still with us, Honorable Matiwani. You may please go ahead.
Thank you, Chair. If I'm wrong, correct me. In a constitutional court judgment, Levenstein and the others versus the state, the constitutional court gave Parliament 24 months to enact a remedial legislation that is before the 14th of June 2020. Now, is this amendment bill in line with that remedial legislation from what I was trying to look at before I came to the meeting? Thank you, Chair.
Honorable Matiwani, it's in relation to the prescription bill, your question.
The current amendment bill that is before us, I was checking is this as a consequence of the Constitutional Court judgment of Levenstein and others versus the state, that Parliament must come 24 months. Are we talking the same thing here, or is this something else?
Okay, I think Deputy Minister, you can respond to that. Yeah, I think it's in addition to what the Constitutional Court judgment said. It's actually two. So let me hand over to
Look, it's partially. So as it amends the Criminal Procedure Act in line with the Levenstein judgment, but then it also goes further and deals with an aspect that wasn't included in the applicants in the Levenstein judgment. Is new, but that would in all likelihood, I mean, policy-wise, they relate, as members would probably know, to situations where children usually very often are raped, abused sexually when they're children, and then by a close family friend or family member, and then get out and are unable to proceed with matters at that time, and giving them the right still to proceed with those matters, as in this particular case. So that's where it's from. This bill, we have now missed the deadline of the 24th. This one, before the Concourt had ruled, which on reflection wasn't the best way to go, because as Mr. du Preez has said, it was finalized by, if there hadn't been COVID, then I think we would have made the deadline, because the Portfolio Committee in, I think, early March, and then unfortunately not put on the order paper until a few weeks ago. Otherwise we would have made the deadline, but similar in this matter, because again, there's a reading in. But it must be the other issue of retrospectivity, and on that matter, if you want.
Thank you, Madam Chair. Thank you, Madam Chair. Madam Chair, with regard to the retrospective application of the law, there are two concerns which have already in the past been addressed when we get to a provision like Section 18. The first is the principle of legality, which if you committed a murder, 40 an offence, and it is still an offence. So with regard to the principle of legality, there's no problem to prosecute the person in those most serious cases or serious offences. And then the other concern or criticism that was raised against a provision like Section 18 is the whole issue of the right to a fair trial, and we've already have an indication that the approach by the courts is that it will not affect the right to a fair trial negatively, because it all depends on whether the state has a strong case against you or not. So those were the two concerns that were usually brought out against a provision like Section 18, but I do not think that that is something that is a stumbling block at this stage. I might just add that Section 18 was amended in 1990, just prior to 97, after the Makonyane case, where the death penalty was declared unconstitutional. Section 18 did not list offences. It merely said that in respect of an offence for which the death penalty may be imposed, the right to institute prosecution in those cases never prescribed. But in short, Madam Chair, retrospective application of Section 18 is not a concern.
No, thank you, Mr. Dupree, and thank you, Deputy Minister, for those responses. I don't think we have any follow-up questions, but perhaps just to indicate to members that we will have a lot more time to go more in depth in terms of this bill, as well as put it out for public comment or public written comments. And once those comments also engage in more depth in terms of this bill. With that said, let me thank Deputy Minister and his team for the presentations that they've made. It does help clarify quite a few issues that members might have had. And obviously, Deputy Minister, further engagement from yourself. With that said, thank you very much, Deputy. We actually going to go on to the next item on our agenda, which is adoption. I'm sure you wouldn't want to be part of that, but let me release you. And yes, we will be in contact with yourselves in due course.
Chair, thanks. Yeah, if we can be released. I hope Mr. Matiwane is also going to leave, but maybe he wants to hear the minutes as well.
No, Mr. Matiwane is most welcome to remain. Yeah, no, thank you. Honourable members, we're moving on to the next item of the agenda, which is the adoption of minutes they intend adopting. Members will recall in forgotten about adoption of minutes. As a result, you'll find it is part of the package for the current meeting. Gershwin, if you could sing up the slide or the minutes. Our members, we'll deal first with the minutes of the 18th. In that meeting, in that meeting, we deliberated on the Civil Union Amendment Bill, where we agreed on whether or not the committee should conduct public hearings on the bill. And we also, we deferred, we also considered and adopted minutes of the committee meetings. That there were 5 set of minutes at that day that we dealt with. All members were present in the meeting. Apologies were received from Honourable Mola. Honourable members, the minutes were sent to you. I think Gershwin has already gone down page 2, which is the bulk of the content of the discussions. Those would want to make, please not, if you are in agreement with the minutes, if I can get a mover for the adoption of the minutes. I see Gershwin has made one correction. Our members, are there any additions to the minutes? Corrections, additions, our members? If not, can I get a mover for the minutes? Adoption of the minutes.
Adoption of the minutes, Chair.
Thank you, Honorable Nita. Can I get a second, honorable members?
Yes, ma'am. I second.
Honorable Fayela, thank you very much, honorable members. Honorable members, the next set of minutes is dated the 29th of May 2020, the date of the meeting. Our members, in that meeting, we received a briefing by the Ministry of Justice on the Judicial Matters Amendment Bill. And in that meeting, we also dealt with adoption of the International Treaty on Extradition and Mutual Legal Assistance between South Africa and Mexico. We also, at that meeting, dealt with the report on the Magistrate Mkhanzi matter. The report on our engagements in terms of budgets and APPs for the South African Police Services, for the Civilian Secretariat for Police Services, as well as the Independent Police Investigative Directorate. All members were present in the meeting, but we received apologies from Honorable Goia, Motsanai, and Dango. I think, Gershon, if you can go down in terms of page. Yeah. So in essence, we received the briefing and we dealt with adoption of the Mexican treaty reports and adoption of the Mkhanzi report. And then the adoption of the budget and APP reports. Our members, are there any additions? If not, is there any member that would like to move for the adoption of the minutes?
Chairperson, I move that the minutes be adopted.
Thank you, Honorable Mola. Any second, honorable members?
Nita is seconding, Chair.
Thank you, Honorable Nita. Thank you, members. The minutes are duly adopted. We'll then move on to the minutes of the 3rd of June, 2020. Members, in this meeting, we received a briefing by SAPS on the notice for a declaration of amnesty in terms of the Firearms Control Act. And as I indicated before I started, the 2 minutes which we did not adopt but ended up being deferred. Our members, in terms of members that were present, all members were present. We only received an apology from Honorable Dango. Gershon, if you can go down on the document. Yeah. So, our members, we received the presentation from SAPS on the request for amnesty, and we engage on the presentation. Are there any additions or corrections to the report? Our members, if there are no additions or corrections, if I can get a mover for the adoption of the minutes.
Chairperson, I move that the minutes be adopted.
Honorable Mola moves for the adoption. Can I get a seconder? Honorable members?
I second it, Chairperson.
Okay, I heard a few voices.
I withdraw. I withdraw.
It's Honorable
I
Matsamai.
second it.
Thank you, Honorable Matsamai, and welcome. I didn't greet you earlier. Honorable members, can we move then on to the next set of minutes dated the 4th of June concerning the meeting that was held on the 4th of June, 2020. Kishwan, that's the 10th. While Gershwin is putting it up, honourable members, in that meeting, we deliberated and considered written submissions on the Civil Union Amendment Bill. We received a briefing on the legal opinion in terms of public participation, and we also dealt with responses to the written submissions on the bill. I think in that meeting, all members were present except Honorable Motsamai and Dango, and an apology from Honorable Mola and Guia. Honorable members, are there any addition to the minutes and or corrections? If not, can I get a mover for the adoption of the minutes?
I move, Chair, that they have through reflection of the discussion, Chair.
Thank you, Honorable Nita. Can I get a seconder for the adoption of the minutes? Honorable members?
I second.
Thank you, Honorable Fayela. Honorable members, we're left with just 2 more minutes. If you can, 2 more sets of minutes. I didn't mean minutes, but sets of minutes. The meeting that was held on the 10th of June, 2020. Yeah, honorable members, in terms of this meeting, we dealt with the cybercrimes bill, where we received a briefing by the parliamentary legal advisor in the department on the proposed amendments, and we further deliberated in terms of the proposed amendments to the cybercrimes bill. All members were present in that meeting, and we received an apology from Honorable Dango. Honorable members, if there are any additions and or corrections to the minutes, please indicate so. And if not, if I can then get a mover for the adoption of the minutes.
Chairperson, I move that the minutes be adopted.
Thank you, Honorable Mola. And if I can get a seconder for the adoption of the minutes.
Nita seconds, Chair.
Thank you, Honorable Nita. Honorable members, we'll now move on to the last set of minutes dated. The meeting was held on the 11th of June, 2020, and honorable members will remember it was held in the evening, and it was quite a lengthy meeting. We dealt with quite a few matters that evening. We dealt with we received a oh yes, so we received a presentation by the Department of Justice as well as the Magistrates Commission in terms of regulations as it affects leave for magistrates. We also dealt with the we also adopted the report in that meeting. We then dealt with the proposed amendments to the cybercrimes bill, as well as adopting the report on the consideration of the cybercrimes bill. We also dealt with the adoption and consideration and adoption of the report on the Civil Union Amendment Bill. And lastly, we dealt with the consideration and adoption of the Declaration of Amnesty in terms of the Firearms Control Act. All members were present in that meeting. There was just an apology from Honorable Dango. Honorable members, it was quite a lengthy meeting. If there are any additions or corrections to the minutes, if not, can I get a mover for the adoption of the minutes?
Chairperson, I move that the minutes be adopted.
Thank you, Honorable Mola. And if I can get a seconder for the adoption.
Nita seconds, Chair.
Thank you, Honourable Nita. Thank you, Honourable Members. The 6 sets of minutes are duly adopted. Let me also thank you once again for your attendance and participation in terms of this meeting. It's appreciated, and also thank Honourable Moimang for also making the time in terms of attending today's meeting. The position from the Northern Cape has not yet been filled in terms of representation from the Northern Cape. Honourable Moimang, thank you very much. With that said, honourable members, let me thank you once again and declare the meeting closed. Thank you, and have a good evening.
Good evening, ma'am. Thank you so
And
much.
you too, Chairperson.
Thank you, honourable members. Thank you, Honourable Moimang.
Mfaela. Mfaela mkhaya
Thanks, the
wami.
Honourable.
Hey,
Zandile.
siyamkhumbula umfana wethu. Siyamkhumbula umfana wethu.
Hey, Mfaela wethu siyamkhumbula.
Hey, mfana wathula sikhumbula suka.
Hayi suka uzenza